Hi, I'm Kathryn Krase, and this is the Making the Tough Call podcast. I'm a social worker, lawyer, and longtime mandated reporter trainer. Please note that while I am an attorney licensed to practice law in New York State since 2001, I am not your attorney, so nothing I say in my recordings should be considered legal advice. Today, we're going to talk about whether social workers who work in lawyers' offices are mandated reporters. In 2024, at a hearing of the New York State Assembly Committee on Children and Families, various professionals, including myself, as well as systems impacted people, testified about how current child abuse reporting practices hurt children and families instead of helping. One particular testimony, offered by Sarah Hedden, an attorney and social worker, as well as a managing attorney for the Center for Elder Law and Justice in Buffalo, highlighted an often ignored question. Are social workers who work in legal settings still mandated reporters of suspected child abuse and neglect? Let's explore that. Social workers in all 50 states are mandated reporters of suspected child abuse and neglect. Social workers also have a general obligation to keep client confidential information. The NASW, National Association of Social Workers, Code of Ethics expects social workers to breach client confidentiality in certain circumstances, like when necessary to prevent serious, foreseeable, and imminent harm to a client or others, or required by law, mandated reporting. When social workers work in legal settings, the role of mandated reporter conflicts with the legal and ethical obligation of lawyers in that practice to keep client information confidential at a higher level of protection than is expected of social workers. The difference in legal and ethical expectations creates a conflict between the two professions. Since most social workers never work in legal settings, they rarely consider this conflict. However, the practice of social workers in legal settings is more and more common. Interdisciplinary opportunities for lawyers and social workers have expanded significantly, especially in New York State over the past few decades. Most of these new opportunities come from legal service organizations that have hired social workers in order to provide what we call wraparound or supportive services to clients. This kind of interdisciplinary practice is most common in criminal and family defense work. In this practice, lawyers provide the primary professional service. The client has certain expectations when hiring that lawyer. When a client seeks to retain an attorney for representation in a legal matter, attorney-client privilege and confidentiality are standard. As a result, the client should feel really comfortable sharing information with their attorney because the attorney is not going to share that information with others. In fact, lawyers can't fulfill their constitutional obligation to their clients if the client is not secure in the fact that the information they share with the legal team will not be provided to the government who's prosecuting them. Under the American Bar Association's Model Rules for Professional Conduct, Model Rule 5.3, anyone working under the direction of a lawyer must assure that their conduct aligns with the lawyer's professional obligations. For instance, communications between administrative aides and paralegals employed by the lawyer or law firm and the client are confidential and protected by privilege. The same could or should be expected of social workers working under the direction of the lawyer, but social workers are also expected to adhere to their own code, the NASW Code of Ethics. So we're left with an interdisciplinary conflict. In an effort to settle this conflict, various entities have evaluated whether social workers remain mandated reporters when working in legal settings. In 1990, the Maryland Attorney General explored this issue and determined that when social workers are working in support of the lawyer's role with a criminal defendant already under prosecution, the social worker is no longer bound by their role as a mandated reporter. The National Association for Public Defense conducted a legal analysis that also concluded social workers supporting attorneys in the role of public defender are not mandated reporters. The DC Bar Association, however, asserts that there's no clear answer to this question, and thus clients have the right to know that the social worker in interdisciplinary practice might be obligated to make a report. And the Kansas Attorney General, following the DC Bar Association reasoning, they issued a largely identical opinion to the DC Bar in 2001. In 2005, the Nevada Bar Association determined that social workers in these roles are bound by the attorney's duty to protect client confidentiality, and thus social workers in these roles are not mandated to report suspected child abuse. The National Association of Social Workers, the NASW, referenced all of these evaluations and opinions when they made recommendations to social workers in 2008. The NASW did not make a clear determination on the question, but instead provided social workers the ability to make a decision they themselves deem appropriate to their role and the state that they practice in. The NASW recommends social workers anticipate the potential conflict when entering into interprofessional practice with attorneys and address the issue prior to the problematic situation arising. Since the law does not provide a definitive answer as to whether social workers who work in legal settings are still mandated reporters of suspected child abuse and neglect, social workers should apply their own ethical values, as clarified by the NASW. In interdisciplinary practice settings, there are many social workers who firmly believe that their obligation as a mandated reporter is eliminated when the primary role they play is in supporting the client's legal representation. In many of these settings, social workers commit to that perspective even before employment. Other social workers firmly believe that there's nothing that can eliminate their mandate to report. No matter the decision made by the individual social worker in interdisciplinary practice, the choice should be clear to both the client and the attorney engaged in the professional relationship. With clarity on the role of the social worker, the client and attorney can make choices as to how they interact with the social worker in that setting. I hope that was helpful. For more information, resources, and training opportunities, check out my website, www.makingthetoughcall.info. Thanks.